Can't allow you to proceed while you're driving a vehicle.
No, I'm saying I'm parked. I'm filling up parking now. It seems like you're practicing law from the bench. I'm going to respect your courtroom, but I disagree. Yes.
Sir, you have to stop interrupting.
Penalty and perjury.
If you stop speaking when I'm speaking.
Your Honor, he's coercing. And since there's no statute of limitation for fraud, he's wasting judicial resources. Honor my counterclaim to dismiss this matter.
So based on the proofs on the record.
Yeah, you need me to stop? I mean,
I need you to stop, sir. I can't have you driving
give me
while
15 seconds. I can pull it back up to my family house.
No, I can't allow you to proceed while you're driving a vehicle.
No, I'm saying I'm parked. I'm filling up parking now. I'm parking, right? 5 seconds. Okay, I'm done, Your Honor.
You recall in reviewing your business records, if a foreclosure was conducted with regard to this property?
Yes, it was.
Objection, Your Honor, hearsay.
Okay, overruled. You may respond, sir.
On what grounds? So I could maintain the error for the record when I appeal this, if this don't go accordingly?
Okay, it's a business record, sir.
All right, guys, buckle up, because today we're diving into a courtroom showdown that's anything but ordinary. A routine hearing takes a wild turn when a sovereign citizen storms in with paperwork and defiance, challenging the court's very legitimacy. From the moment he speaks, it's clear he's not here to cooperate, but to confront. His calm yet cryptic opening creates immediate tension, leaving the judge and court staff visibly baffled by his logic and intent.
Respect your courtroom, but I disagree. I disagree is tremendous. So, okay. Court reporter, can you please note that the honorable judge, I'm stating he's practicing law from the bench without facts.
But your objection is part of the record, sir. All right. You may continue, Mr. Duher.
And is this a true, correct, and complete copy of the sheriff's deed of mortgage foreclosure, to the best of your knowledge?
To the best of my knowledge, yes.
And is this sheriff's
objection, Your Honor? Can he vow to that under penalty of perjury? That's the original document.
Your Honor, he stated this to the best of his knowledge.
No, under penalty and perjury, can he contest that that is the original document with the wet blue ink signature? Penalty and perjury.
All right, sir. That's not the question. The question is whether he can identify the document.
Under penalty and perjury, can it be yes?
Sir, you have to stop interrupting.
Penalty and perjury.
You can make an objection, but once you've stated your objection, you have to stop.
Yes, Your Honor.
All right.
And for the record, Your Honor, I do have counsel coming for this next court date. They obtained, as soon as he get back in the country, he will be jumping in to take care of this matter further. So I'll ask if you just give my counsel some time before any permanent decision is made so they can review these books, all interrogatories, so we can make a fair decision, because I'm not arguing it's a debt.
The energy shifts fast as the man launches into sovereign rhetoric, refusing to recognize the judge's authority. He questions the court's jurisdiction and insists he's there under duress, clearly rehearsed in pseudo-legal tactics. The judge maintains composure, but you can sense the rising tension in the room. This isn't about a simple RV payment. It's a standoff between reality and delusion, with the courtroom caught in the middle.
And I've been trying to honor the debt, Your Honor. I'm not arguing that it's a debt. I done did everything possible to honor this debt. They have not been in compliance with it.
And Your Honor, I would object to that, given this would be our third hearing, and he had ample time to get counsel.
Objection again.
All right, let's take one issue at a time, gentlemen. I can't be expected to remember 3 or 4 objections all at the same time. I'm going to overrule the objection on the basis of a business record exception. As to the request to adjourn the matter for Mr. Bay to retain counsel, I'm going to deny that request. Mr. Bay is
on what grounds, Your Honor? Because I never got served directly.
If you stop speaking,
that you stated that, Your Honor. This is my first time requesting any adjournment to bring in incredible counsel who can handle this matter fairly on my behalf.
At this point, I don't even see that you have standing to participate in this case, although I guess we will get to the proof on that issue. So,
so Your Honor, you don't have my deed of records right there. You don't have me as a deed owner. You don't have me as a certificate owner in the record. I put all that on the record. So for you to say I don't have standing is kind of unfair from my understanding.
And was that redemption date?
Things get even wilder as he continues rejecting the process entirely. He refuses to sit, refuses to identify himself properly, and keeps insisting. He's a private citizen. His goal is clear: derail the hearing with confusion and jargon. The judge begins to lose patience, making it clear this isn't a game. But this man is determined to play his part to the end, no matter how much sense it doesn't make.
September 27, 2021.
Your Honor, he's coercing. He coercing Mr. Dewhurst.
As a government record and/or document recorded with the applicable recorder of deeds for this document.
Okay, any objection to that, Mr. Bay?
Absolutely objection.
Okay, and what's the basis for your objection?
He's a third-party debt collector. He's not a real party in interest, and he has no first-hand knowledge of any of the affairs that took place with this mortgage or at this closing table. And that Mr. Dewhurst he's not eligible to bind a corporation. Do he have the status of a CFO or a CEO in that company?
Okay, so the objection is that this witness doesn't have the
First-hand knowledge to any other matters.
Okay, all right. So the objection is overruled.
And has Carrington ever conveyed any of their ownership?
Objection, Your Honor. Objection.
What basis, sir?
Rightful owner as the title, rightful owner as complete ownership of the property. Can't just take away my interest like that without facts. You guys still have not had no verification of debt. What you have in your hands, Your Honor.
Now, the judge delivers a sharp reality check, warning the man that this nonsense won't stop the legal process. But instead of backing down, he doubles down, citing imaginary rights and false legal codes. The frustration in the courtroom is boiling over. Even spectators are starting to sense this is less about justice and more about disruption. It's a masterclass in how misinformation can weaponize confusion in a serious legal space.
We done reached out. They cannot verify that debt, and they cannot verify that they ever loaned Rachel Brown and Matthew Brown any money for this mortgage. They can't. They can't prove that, and they haven't yet, and I've been waiting. I just want to know if they're a real party in interest, are they a real creditor in the amount, so we could handle any financial obligation if owed. They are yet to prove that. Like you said, I got the deed, and it's sealed by the county records. I have the warranty deed as well, and it's sealed by the county records. Objection. Can you prove I didn't redeem and attempt to redeem? Can you prove that it hasn't been corresponding and negligence on you guys' behalf?
Overruled.
The property was foreclosed on and Carrington took control of it.
And none of your reflect.
Objection.
None of your record.
Objection.
And once again, you have not.
What's your objection?
That's not credible. That's not credible.
Sorry, this is not your time to ask questions, Mr. Bay. Mr.
Okay,
Johnson.
let me know when I'm credible to ask questions.
All right, Mr. Johnson, any other questions?
Has Carrington ever conveyed ownership of the subject property to any party?
No.
Thank you. No further questions, Your Honor.
Objection, Your Honor. Matthew Brown, not the owner at the time that they
Mr. Bay, this is your time to ask questions.
At this point, the judge starts issuing commands to maintain order. Security steps up, and the man's calm tone starts to crack under pressure. He tries to act like he's still in control, but his arguments are unraveling. The court isn't buying it, and his strategy is clearly failing. His refusal to comply only strengthens the judge's stance. This part right here, it's where the illusion of control begins to fall apart.
So if you want to ask any questions to Mr. Dewhurst, you may ask questions to Mr. Dewhurst.
Okay, Mr. Dewhurst, is it not law that 15 USC 1692G requires verification of any debt?
Your Honor, I object as to relevancy.
Again,
okay, what's the relevancy, Mr. Bay?
I'm establishing bounds for fraud. And since there's no statute of limitation for fraud, I'm going to make sure if they're not the original creditor, that it's fraud.
You didn't respond to the relevancy or how this is relevant.
The relevancy of 15 USC 1692G, it binds any corporation or anybody who's saying there's a debt or a balance to verify.
Okay, so this is the time to ask questions, not to argue law.
No, so I'm not trying to. I'm asking a question. That was a question.
You have a question regarding the facts for Mr. Dewhurst. Okay, you may proceed.
Yes. So again, Mr. Dewhurst, under 15 USC 1692G, do you have to verify a debt?
Your Honor, I'm going to object again regarding relevancy, Your Honor. This is, unfortunately, he does not have standing to bring any claims of verification.
Objection. I'm a real party in interest. Objection, Your Honor.
The courtroom tension peaks as the judge finally has enough. She lays down the law hard, ordering action against the sovereign citizen. As officers move in, you can see the shift. He's no longer the confident disruptor, but a man out of moves. His theatrics didn't buy him freedom, they earned him consequences. And this moment hits different. It shows how far courts will go to shut down chaos and restore order.
He doesn't have any standing. He hasn't proven he's more than a third-party debt collector yet.
Your Honor, after the foreclosure period ran,
Your Honor, we don't know if this is credible foreclosure. Can I ask my questions, Your Honor?
All right, gentlemen, you cannot speak at the same time.
Next question. So, Mr. Dewhurst, are you conscious of the verification of that letter that been sent to your company twice that I sent with behalf of Matthew Brown and Rachel Brown that they're yet to respond from? My notary sent it. The notary republic sent it.
Your Honor, I would have to object.
Yes or no?
Sir, you have to let Mr. Johnson state his objection. Mr. Johnson, what's your objection?
Your Honor, she's asking the witness to respond to a vague request if he has any notice, but I would ask that he would only ask as it relates to the business records, Your Honor.
Objection, Your Honor. I sent that to the business and record department, and I sent it attention to the CFO of the company.
Okay, well, you can't ask multiple questions within the same question.
Okay. Well, Mr. Dewhurst, what was the problem answering the verification of that letter?
Even as he's being removed, the man tries to shout over the judge, clinging to his rhetoric until the last second. But the courtroom is done entertaining the act. The judge delivers a final statement that cuts through all the noise. This is a court of law, not a stage for fringe ideologies. The crowd watches as he's taken out, and what began as theater ends in complete defeat. It's the fall of a fake system against real justice. If you have that in the record, so we've been asking for the original.
Objection, Your Honor. He stated that he was not aware of a letter.
You're right. Correct. So I should say then, moving forward, is there a problem producing the original contract with the wet bluing signature from Rachel Brown and Matthew Brown? If you have that in the records.
Okay, so you have a question for Mr. Dewhurst?
Yes, Mr. Dewhurst. Is it fair to say you cannot prove that the original, you don't have access to the original copy of the note of the mortgage?
Yes, I'm
under
sure.
penalty and perjury. Do the company have it, Mr. Dewhurst?
So you may ask another question.
And okay, also, for you, Your Honor. So it's also credible and fair to say he has no firsthand knowledge of anything as well.
Okay, so that's an argument. That's not a question. Okay. So yeah.
All right, I'm learning. I'm sorry, Your Honor. Thank you for your patience. So Mr. Dewhurst, under penalty and perjury, can you confirm that your company followed all GAP procedures with this process?
Objection, Your Honor.
So I guess the last question, again, I just want to confirm that Mr. Dewhurst, you have no firsthand knowledge of the
And there it is, folks. The courtroom reclaims its silence, the judge returns to order, and the sovereign citizen exits not with a win, but with a lesson. No matter how loud the argument or bizarre the theory, the law doesn't bend to fantasy. This case reminds us how misinformation spreads, but also how the system stands strong when tested. If you enjoyed this breakdown, don't forget to like the video, subscribe to the channel, and we'll see you in the next one.